Good afternoon, everybody out there in Cyberland. Welcome to Michael Lynch's webinar this afternoon. We'll be talking about the dangers in divorce, property settlement traps, following on from Michael's webinar earlier in this year. Firstly, I'll just give you some background about myself. My name's Amy Honan. I'm a senior associate at Michael Lynch Family Lawyers. I've been I am an accredited specialist with the firm and been specialising in family law for the previous 10 years. Just before we start as well, just a little bit about our firm, Michael Lynch Family Lawyers. We're a firm that deals with family law matters exclusively and de facto relationship matters. It's a firm which has been established for 20 years, and quite excitingly you'll see in the bottom left-hand corner that we're celebrating our 20 years of service this year. There's 9 lawyers with us with over 100 years combined special experience, with the majority of us being accredited family law specialists. We are also one of the biggest boutique family law firms in Queensland, and particularly in the Brisbane area. Many of you may already be signed up to our newsletter, and maybe how you've come across this webinar today. We have a fortnightly newsletter that goes out and would have come out to you today if you signed up. If it's something that you're interested in being subscribed to, please send us an email at the end of the webinar, and we'll be able to get that through to you. Just going through a bit of an overview about what I'm going to be speaking about today. Firstly, what is a divorce? I know that Michael's webinar earlier in this year spoke about it, but I'll just be expanding on that a little bit, and a bit of a refresher for some of you out there. I'll also be speaking about the time limits in family law settlements. What's the time limit for married couples, and what's the time limit for de facto couples that have separated? They are different. Then we'll be honing on in relation to some property settlement matters. So looking at how superannuation is considered in property settlement matters, and talking about a few examples. I'll also then be talking about the treatment of gifts, loans, lottery wins and inheritances, and how the court would consider those. Also regarding post-separation contributions and how a court will look at those. In the family law courts at the moment particularly, we're seeing further and further delay in regards to matters being able to be heard, or parties that may decide to delay formalising any property settlement. It's becoming more and more common, and definitely an area of interest. Lastly, I'll be speaking about special contributions, and particularly, does the entrepreneurial spouse receive more in a property settlement? This is probably what a lot of us as family lawyers do here in family law matters, a bit of a he said, she said, and sometimes what the judge thinks. So just a bit of a light-hearted meme there for us to have a look at before we launch into the seminar. Okay, for the first one, let's talk about what is a divorce. The only ground for divorce in Australia is that the marriage has broken down irretrievably. Fault is not a ground in Australia, and whilst clients often want to tell us the reasons why their marriage has broken down, and curiosity, to be honest, can get the better of all us family lawyers, for the family courts and for the judges, the only reason why the marriage broke down, the reason why the marriage broke down is irrelevant. Divorce will be established if the parties have been separated for 12 months. Therefore, the earliest an application can be filed is 1 day after the date of the first anniversary of the date of separation. So an example there, if Brad and Angelina were living in Australia and sought a divorce, if they had separated on the 1st of August, the first opportunity they would have to apply for a divorce would be on the 2nd of August the following year. The granting of a divorce doesn't determine issues of financial support, property distributions or arrangements of the children. It is a completely separate application, and many of our clients will prepare the application themselves because it is quite a procedural application. If there's issues in perhaps locating the former husband or the former wife, or there's a dispute about the date of separation, that may be more commonly when we are involved. What's also important to note, whilst it is separate from property and children's issues, is by having a divorce order issued, this will affect a party's will in all states in Australia except Western Australia. It will affect part of the wills where the former spouse has been listed as a beneficiary and executor, but in Tasmania it will affect the entire will. So just things to keep in mind if you've got a client coming to you who's indicated that they're intending to divorce. Whilst it is something that I guess us as family lawyers don't prepare wills, just something to keep in mind, and I'm sure you would be keeping in mind when giving that advice to your clients. Next, move on to what is separation. So separation has been held to be more than a physical separation, and it involves actually the breakdown of the marital relationship. Broadly then we're looking at the court looks at three elements: the intention of one or both of the parties to end or not resume their relationship, the parties or one of the parties acts on the intention that the relationship has come to an end, and lastly, where one party alone considers the relationship's at the end, that party must communicate that attitude to the other party. So parties can, as we've put on the slide here, separate under one roof. Things that the court would be looking at in those circumstances to demonstrate that there has actually been a separation is that the parties are, they've ceased a sexual relationship, they've started socialising independently, they've separated their finances, they are cooking separately, doing their own washing. All those things would assist in mounting to being separated under one roof. Separation can be quite interesting in the sense I had a client come in and see me last week actually, where they had been married in June 2013. She listed on the intake form that we had that she separated in December 2013, so a short relationship of 6 months. And so she's come to see me 3 years after she said that she separated. The parties had been living physically separated since they were married, because the husband in that case was a doctor and was doing regional work, but he would come down, particularly in the 6 months beforehand, before the separation, to visit the wife. But what made it interesting is that they continued to use a joint bank account post-separation, but more interesting that they actually purchased 2 properties past their separation. One was in his name and one was in her name. They also had holidayed overseas together, and there was a short period at the beginning of this year where they had separated or resided under the one roof when he had some locum work in Brisbane. It was one of those matters where it wasn't a clear-cut area of separation, and I did indicate to her that if there was a dispute about the date they had actually separated, that it may be a situation of her obtaining documents and affidavits from other work colleagues or family members that could depose to them actually being separated, even though they continued to have joint use of a number of items, particularly they were joined financially. We'll now move on in regards to property settlement, time limitations. So we've spoken about divorce previously, and we're looking at their marriages have a limitation date to either bring an application for property settlements in the family court or in the Federal Circuit Court 1 year after the divorce order issues. De facto relationships have a different limitation date, and that's 2 years from the date of separation. It is as a matter of course that we find that there is more dispute as to time limits in regards to de facto settlements, particularly because the date of separation, or the limitation date I should say, isn't as clear as it is for married people, because we've obviously got the divorce order and we can clearly know when the date starts. it can be that in matters that we have where we have to actually dig down and get evidence from other people to work out when the date of separation had actually occurred. You may perhaps be approached by one of your clients if they've come and seen you post-separation, whether there's any file notes that you have in which you've listed the date of separation as some evidence from an independent third party that they were advised the date of separation. We've also had a matter previously where there was, again, a de facto matter and a dispute about the date of separation, where we've sought for Centrelink documents to be disclosed in circumstances where we, in that case, acted for the de facto husband, wanted some proof to show that the de facto wife in those circumstances had told government agencies that she was in fact separated from the de facto husband. It's important if you know that your client is in a de facto separation or has been divorced, ensure it will, particularly for us, to ensure that their their limitation date is diary noted, and if it is coming up to a limitation date, commencing proceedings in the family courts or the federal circuit courts to preserve that limitation date. Again, just some little light-hearted memes here, just for a bit of a laugh. Sometimes it does feel like that in the courts. We've got the rock, paper, scissors and who's getting what, particularly when it comes to chattels. There's a bit of a rumour that's gone around the family courts about a judge, when there was a dispute about a chattel, put it in a week on, week off kind of care arrangement like a child, but that could just be an urban myth that's been going around for a few years as to whether that actually did occur. Just before we launch in a little bit further, just a quick refresher in regards to property settlement and how they're determined under the Family Law Act. Firstly, the court must consider, after the case of Stanford, which was a High Court case, is it just and equitable to proceed with a property altercation? In most cases, the parties merely separating will mean that the court does consider it to be just and equitable. In rare cases, it may not be appropriate, and some of the category of cases that might fall in is when there has been a very short relationship, married or de facto, no children, and the parties have intentionally not intermingled their finances. That may be a case where the court finds that because of the intention of the parties, it's not just and equitable to proceed with a property settlement. Another example may be if the parties decide that they will informally put in place a property settlement and do all things to put that informal property settlement in place, but don't document it in a legally binding consent order or financial agreement, then the court may decide, well, because of the actions the parties had undertaken, that it wasn't just and equitable to proceed with a property altercation. But as I said, in most cases, the court will find it's just and equitable to proceed. We then move on to 4 steps which the court undertakes. The first is to identify the value of the property of the parties. So that is a bit of an all-encompassing in the sense of anything in one party's name or joint property. So a property in the wife's name only, for example, would become part of the property pool. Any interest in a company or a family trust would come into that first step, and superannuation as well. We then would get a net figure of what the property is worth, and everything is valued at the date the court does the property settlement or the parties reach an agreement. The second step then is to consider the contributions between the parties. This would include any initial contributions that the parties had and any financial and non-financial contributions that they've made during the relationship and post-separation. We're going to explore some of those examples as part of today's webinar. The court will consider those in percentage terms, looking at obviously the length of the relationship and when those contributions were received and how they are reflected in the property pool identified in step 1. The third step then is to look at future need factors. So the court can make an adjustment in one party's favour if they have circumstances in the future which justify a need for an adjustment in their favour. Some of the common adjustment factors for future needs would include the one party having the primary care of a child or children of the relationship, if there's an income disparity in regards to both the parties, if one party has some health concerns that affects their ability. Some other things that the court may consider at this third step of future needs is to also consider whether a party has access to a financial resource. I'm going to take some time to explain what a financial resource is now, as I'll be referring to this a few times coming up in the slides. A financial resource isn't defined under the Family Law Act and is thought to be of something which is not property included in the asset pool, but is a factor for the court to take into account because of the future benefit to one party. It's quite broad and basically includes resources which have the ability to generate an income. Some examples of financial resources include long service leave, if it has an ability to be taken in a form of cash, a future pension entitlement, any tax losses, an anticipated inheritance, and overseas superannuation. Moving on then to the fourth step, the court then has to consider that the division that it reaches is just and equitable. What a good example is in regards to a just and equitable, I find, to explain to my clients, and is that a property settlement where one party was going to receive all the superannuation and was of a spring chicken as such and had quite a few years to access it, and the other spouse was going to retain all the non-superannuation assets like shares, cash, or the equity in a form of matrimonial property. The court's not going to consider that to be a just and equitable settlement. It will have to look at dividing the assets as such to provide for one spouse to receive some of the liquid assets and some of the superannuation. We've just put a note in here as well on this slide in regards to section 81 of the Family Law Act, which is what's called the clean break principle. This puts the obligation on the court when it's looking at putting orders in place to ensure that the orders provide finality and untying the husband and wife or the spouses from each other. This would mean that orders would have to provide for example, a family company for one spouse to retain it to the exclusion of the other rather than continuing to hold an asset jointly in the years to come. So firstly, let's have a chat about superannuation. So pre-2002, superannuation was not defined in the Family Law Act. This meant it was considered a financial resource. And would have been considered under that step 3 as a future needs of the parties. The options available to the court at that time were either to defer applications until member superannuation became payable, and depending on the age of the parties could obviously have a significant impact on them, and really was in contrast to that section 81 of the Act, which talks about the clean principle of the parties. The other way was to calculate the present value of a superannuation interest and split non-superannuation assets accordingly. The reality of this, though, in very traditional relationships would result in the husband having a superannuation interest that he wasn't able to access for many years, and the wife having a property settlement which obviously gave her a lot of cash but didn't result in her having any superannuation going into the future. So in 2002, at the end of 2002, they amended the Family Law Act to provide for superannuation to be treated as property, which would allow superannuation to be split by way of a superannuation splitting order. The superannuation could either be split as a lump sum cash amount or a percentage of the account. It also allowed, for the first time, for superannuation to be flagged. Flagging superannuation, a payment flag, is like an injunction on a superannuation entitlement. It will direct the trustee not to make any splittable payments without the leave of the court and requires the trustee to notify the court within a specified period of the next occasion when a payment becomes payable. Once a payment flag has been put on a fund, it can only be removed by a court order or a superannuation agreement, which we'll have a bit of a chat about later. When flags are perhaps appropriate as well is when a member is close to meeting condition of the release. Flagging superannuation cannot be done on funds that are less than $5,000. Interesting as well is that the 2002 amendments meant that overseas superannuation continued to be treated as a financial resource. The jurisdiction only extends to superannuation funds and pensions in Australia, and therefore the court will continue to deal with them under the third step as a financial resource. The notes, however, could be made about making any inquiries with a trustee of an overseas superannuation fund or pension fund as to whether they could split the superannuation or order as part of any kind of property settlement. But again, it's not going to be treated as part of the property pool. It may just be making inquiries overseas to see what can be done with that superannuation fund, particularly if the spouse has left that jurisdiction. There may be ways which it can be cashed in and dealt with. Now we're just going to move on in regards to how superannuation is valued for family law purposes. Member and also non-member spouses can obtain a valuation by serving upon a fund, what's called a superannuation information form, or what us family lawyers like to call a SIF, because you'll probably notice very quickly that family lawyers like to abbreviate anything they can. I hear that accountants like to do that as well. So the SIF will be served on the fund. If it's a non-member spouse serving the superannuation or the SIF, they won't notify the member spouse. So it can be a useful tool if one party wants to know what the value is but don't want to put on notice to the other spouse what they're doing. The trustee can charge a reasonable fee for providing that information. They can range from being completely free. So Q Super, for example, is a fund that doesn't charge any fee, while some of the Commonwealth government funds like Military Super, for example, will charge a fee of $150. I've put a note here about defined benefits. It is so important, I can't stress any further, to obtain a superannuation information form of the fund, particularly how they're calculated, and I'm not going to try and explain how they are calculated in the future. I'm sure as accountants you could probably, I'd probably be doing a big disservice to how it is actually calculated, but it's from my experience that current member statements have significantly different values than what's listed on a superannuation form, which is giving us a valuation of the fund for family law purposes, particularly if we've got a fund that's in a growth phase as well. So just if you've got a client coming in who's trying to look at getting some advice in regards to what their superannuation is worth or anything along, and they've got a defined benefit, so important to get them to complete a SIF form. Also should be noted that if part of the property settlement provides for a party to split some superannuation or receive some superannuation, the court won't make an order until there has been a SIF completed from the fund, really just for the court to ensure that there's significant, by getting the valuation, that there's sufficient, I should say, funds in, or balance in that account to implement the split. Valuating superannuation as well for self-managed superannuation funds, it's usually going to be more costly, but again, depending on what is actually in the fund, whether there's some real estate, it may be important to get a real estate valuer to be involved to provide a valuation. If there's shares or other kind of assets in the fund, accountants may also be involved to ensure that there's updated information there. Usually you might be contacted by us solicitors to ensure that the financial statements are up to date, particularly if interest or dividends have been earned or other expenses since the financial statements are prepared. So we're just again taking those things into consideration. Now we'll move on in regards to superannuation splitting. So a superannuation split can occur either by a court order from the Federal Circuit Court or the Family Court, or a superannuation agreement. So a superannuation agreement is a type of financial agreement that deals with a superannuation interests. In practice, most splits are imposed by a court order, but if you've got a situation where the split of superannuation you want is a little bit unusual, then you might see a superannuation agreement be prepared. Because we've got this additional option that you can specify a method by which a superannuation interest can be split, provided there's a worked example to the trustee demonstrating how the amount is to be achieved. So a practical example of this is one where the parties had reached an agreement in principle that they would split the property pool 70-30 in the wife's favour. Part of that property settlement provided for a house to be sold, and because the house had yet to be sold at the time the agreement was reached, it was difficult to work out how much superannuation needed to be split to the wife to provide for that overall property settlement of 70-30. So in that case, we were able to set out how the formula would be, in the sense of we would work out what the pool was, the 70-30 split, and then that would be how we would be able to work out the split, but still in the meantime being able to formalise the agreement that the parties had reached, and avoid any, I guess, concern that either party would resile from the agreement in the meantime. Also, just ending up at the end of that slide, you'll see there I've put superannuation agreements can only be binding on funds if they're being provided with procedural fairness. What this means is before a court will make an order or the superannuation agreement will be taken to be in effect, is that a copy of the proposed orders are sent on the fund and they have 28 days to respond. I put it a way I explain to the clients is because the agreement provides for them to do something, so technically they are a party to the agreement because they have to undertake something, being splitting super to another person. They need to provide procedural fairness in case they want wording change to make sure they are happy with the orders. Just at the end there, if there's a superannuation interest that has a withdrawal benefit less than $5,000, like the payment flagging, it's unsplittable. When a court's considering whether there should be a superannuation split, some of the things the court will consider is whether there are any children of the relationship. If splitting the superannuation means the primary carer can keep the matrimonial home, they may give them an opportunity to do that. It really will depend on how much, however, if it meant the husband was, or the wife was solely retaining the super, then they may not consider that. They would also consider the needs of the party for cash and saleable assets, the type of fund that's in place. You might have parties that have a defined benefit and they may want to keep that intact. The age of the parties as well. If we've got one party who would be able to access that superannuation sooner than the other spouse, the court may consider it less appropriate for there to be a superannuation splitting order. Okay, so let's have a move on now to considering how gifts and loans and lottery wins and inheritances are considered in a family law matter. So really here we're looking at that step 2 in regards to contributions. So just get my papers here, sorry. So we've got funds from an inheritance or gifts will be treated as a contribution to the party that receives them. So if it is for example, the wife's parents who gifted $20,000 at the commencement of their relationship as a gift to help them out in starting their marriage, then the court would consider that to be a contribution of the wife. Any money that received, however, doesn't get refunded. It really deals with it in a percentage adjustment. It's really going to have to consider the size of the gift and how it is reflected in the property pool, the timing of the gift or inheritance. So if my example I'm talking about now, the wife received the gift in a long marriage of 20 years right at the beginning, then the court's not going to be as interested to give a big percentage weighting to the wife. However, if it was a very short relationship of 2 years and no children, then the court may be looking at giving quite a big adjustment to the wife. They'd also look at how the gift or inheritance was used. So if the gift of the the 20,000 in my example was used as the deposit for the first home, it is reflected in the property pool now, and the court's really going to look at giving that again a percentage adjustment. If, however, we found that the $20,000 was used by the wife unilaterally and wasted for some gambling or something along those lines, then the court may be minded to make no adjustment at all for that gift. So it really is considering the size, the timing, and how it was used. We'll move on now to talk about inheritances and how they can be treated. If the inheritance is received prior or commencement of the relationship, then it will be considered as an initial contribution. If we're talking at ones during the relationship and it was applied for the benefit of both parties, it would be treated as a financial contribution by the receiving party. What I really want to focus on now is inheritances, though, that are received late in the relationship or following separation. Except in unusual circumstances, a party could not be regarded as significantly contributing towards the inheritance received so late in a relationship, and certainly not after the parties separated. Therefore, it is a possibility, but not a certainty, definitely a possibility, that a late inheritance may be quarantined from the balance of the asset pool, or alternatively, the court could deal with it on a two-pool approach. So what the two-pool approach means is that at that step 1, the court would have all the assets that the parties had, excluding the inheritance in one pool, and in the second pool, it would look at the inheritance by itself. It would then do an evaluation of the contributions made to pool 1, being the assets that they all had accumulated bar the inheritance, and then and do the same with the other pool in regards to the inheritance. Really, though, the size of the asset pool available for distribution will really result in a change in how the court could deal with a late inheritance. So if the asset pool is minimal in comparison to the inheritance, and a division of the asset pool excluding the inheritance would be unjust and unequitable, the late inheritance may be included or used in the asset pool. So I might give a case example now in regards to that. So in this matter, the wife received a considerable inheritance post-separation, but in that circumstance, the inheritance had been intermingled with the property pool insofar that it had paid down some of the mortgage, paid for some school fees for the children, and it wasn't easy to identify where all the money from the inheritance was. So in that case where an argument had been made for the inheritance to be excluded from the property pool, was difficult for the judge to consider when it wasn't clear for the judge to identify where the inheritance was now. So in that case, the court had looked at leaving the inheritance as part of one big property pool and giving the wife an adjustment for her post-separation contribution of the inheritance. So just looking now at the slide, when we're looking at potential inheritance and how are they treated. So if somebody has usually a parent and there's provision for an entitlement in their will, but they haven't deceased and they still have capacity to change their will, then it cannot form part of the property pool for division. In situations, though, where somebody has made a will leaving an inheritance to the spouse and they no longer have capacity to change their will, that may be a situation where the court has to give consideration to it in part of the property proceedings, and it would be looked at as a financial resource, and there'd be a percentage adjustment given at that third step. In summary then, dealing with inheritances, if the inheritance has already been received, either initially or during the marriage, it will be included in the property pool and seen as a percentage contribution by that spouse. If it's received late in the marriage or post-separation, it may be quarantined, but again, not a guarantee, but open to the court if it hasn't been intermingled, particularly with other assets. Then where a party is likely to receive a prospective inheritance, the court will not make a percentage adjustment. It will depend on case by case. So really, I guess in summary, what we're saying is there's no real clear rule to apply, and really how a court will deal with an inheritance will turn on its facts. We'll now move on to have a bit of a chat about lottery wins and how they're dealt with in property settlements if clients are lucky enough to win. So if it's received during the relationship, similar to inheritance, it's likely to be considered, well, not same as inheritance, but it will be included part of the pool, I guess is where I was going. It will be considered as a windfall for both parties, regardless of who purchased the ticket, in the sense of joint assets being intermingled and joint funds being used. So neither party will receive any contribution adjustment. If it's received post-separation, it's likely to be included in the property pool, again up to the discretion of the judge whether they decide to deal with it in the one pool or two pool approach. Again, depends if they've intermingled it. Again, it will look at did a party use their own funds to purchase or who purchased the ticket. Now might be a good time to talk about an example in regards to a lotto win. In this case, the parties had been separated for 12 months and the wife received a considerable lotto win of $6 million. The husband filed an application to the family court submitting that the winnings should be included in the property pool, as he alleged that it was purchased using joint funds, even though they had been separated for that 6 months. The judge in that case found that at the time the wife purchased her winning lotto ticket, regardless of the source of funds, he found, there was no longer a common use of property between her and the husband, and therefore he made no contribution to the winning. As such, the only claim the husband might have had to the lottery winnings was limited to that step 3 adjustment for future needs. In that case, the court decided to award the husband $500,000 from the wife's lotto winnings in recognition of the fact that he was 62 years of age and nearing the end of his working life and lacked any formal qualifications, and his business was running at a loss. Another interesting example of a lotto win case was the parties had lived together for 12 years and during the marriage had acquired few assets which they divided informally at the time of their separation. Approximately 18 months after the separation, the husband won $5 million in the lottery. The wife had made contributions after separation to the welfare of the family, and the issue was whether these contributions, together with her financial and non-financial contributions during the marriage, justified a property settlement order that received a portion of the lottery proceeds. In that case, the husband had been a heroin addict in early part of their marriage. She'd supported him financially and emotionally through his addiction. She'd also had supported him while he was studying and assisted with his literary skills. They also had one child who at the time of the hearing was approximately 15 years old, had lived with the husband for a period, but at the time of the hearing had been living with the wife. The husband also didn't have regular contact with the child. He didn't pay child support, and in fact, he'd arranged his finances after the lotto win so that he would be liable to pay zero child support to the wife. He'd also had alleged that the lotto win was that of his mother's and not actually his, even though the case talks to him using the money for his own benefit, and particularly gambling about $100,000 of it away. The judge did find in that case that the full amount of $5 million was available for allocation between the parties because of the significant and non-financial contributions that the wife had made during the marriage, that the wife had the ongoing care of the child, and without any support from the husband, given he had he wasn't paying any child support, and that the future need factors weighed heavily in the wife's favour. In that case, the judge ordered for her to receive 15% or $750,000 of the lotto win. The husband appealed on that case, but it was dismissed. Now let's talk about as well is something that comes up often in our family law matters, as was it a gift or was it a loan? It's not unusual to hear of parents providing money to the parties as part of the marriage, and then when the parties separate, now calling as part of to be reimbursed as part of the property proceedings. Interestingly enough, a matter that we have at the moment, we have a husband and wife who adjusted cattle on the back of their land owned by the husband's parents, and following the separation, the husband paid the parents $50,000, representing $5,000 a year for 10 years for using this land. He alleged he had a verbal agreement with the parents, whilst it had never been called on previously, just past their separation. And in that case, we act for the wife, hasn't produced any documents to verify this loan amount. Our client agrees that the cattle had been kept on the husband's parents' land, but during the marriage, the parties provided a lot of free labour on the parents' farm in lieu of any monetary payment for adjusting the cattle there. Whilst this case hasn't been decided, we've had some mentions before the judge in regard to this, and he's already started to make comments that he's very suspicious that this actually was a legitimate loan that needed to be paid, given the lack of paperwork and the loan never being called upon until the parties separated. So this is, I think, a very useful list in the next two slides of things that if you're having a client who's looking at giving loans or funds to their children or family members, to have a look at that. Post-separation documents are usually going to be viewed skeptically. They'll also look at what evidence is being paid, example, bank statements, whether any interest or principal payments have been made during the relationship on the loan, whether there's been any security provided, so a caveat or a mortgage over the loan, and how long has the loan been outstanding. So as I was starting to say before, if you've got somebody coming in, it'd be important to look at documenting it correctly if they're looking to wanting it to be considered as a loan. If, however, the court finds that the money is not deemed to be a loan, it could still be considered to be a gift, and that spouse would get a percentage adjustment for the contributions in their favour. We'll now move on to talk about how a court assesses post-separation contributions. So it's up to a court to identify what post-separation contributions it would take into account. As I would start at the beginning of the webinar, these are becoming more and more prevalent in the cases that we're seeing. We're really seeing at the moment, we're filing applications, and it's taking between 2 years to 3 years to get for the court to have availability to hear some cases. So we're finding that it's longer to get resolution on the matter, and we need to really look at the court's zoning in, I guess, more on post-separation contributions. So some of the things they might be is contributions to the welfare of the family. So if one party has been the primary carer of children post-separation, they may also consider whether child support was paid by one parent who had paid to the parent that had the primary care. Contributions to the preservations of assets, so whether one party had been paying the mortgage while the other party had the ability to live in the property, or vice versa. Contribution to the acquisition of assets, so if one party has purchased something post-separation and property for themselves, the contribution that they've made for that, the court could look at giving a weighting in that party's favour because of their post-separation acquisition of that asset. Other things that might be taken in consideration are, accumulation of superannuation post-separation, occupation of a home, damages or insurance payments received post. Anything that comes as part of that contribution will be looked at by the court. Inheritance as well, one we've touched upon already. As I said before, from a practical approach, the benefit to effectively quarantining these post-separation assets, particularly inheritance income, is to keep it in its own pool as much as possible. So, if an inheritance received, keeping it in, not intermingling it perhaps with the mortgage on the former matrimonial property, keeping it in a share portfolio or in a bank account would be the best way to do that. An example I guess I could talk to you about post-separations is a recent matter where I've had, and whilst this wasn't a matter that proceeded to trial, it definitely was something that we proceeded to mediation, and the mediator we had was a former judge, and to hear him weigh in on what he would likely do if it was a matter in his list. The parties had separated in 2011. I act for the husband in that. The wife had a solicitor who was a bit of a slow mover. My client had his head in the sand a little bit about it as well, so it was a combination of things about why he didn't want to get it underway. The parties got divorced in 2015, and so it really started to come to a head because we had a limitation date coming up, and the wife got another solicitor, which really did assist in getting the matter to move forward. The property pool in that case was around $2 million by the time we had come to court. But in that case, we were arguing that my client had made some overwhelming post-separation contributions. There were 2 children who were late teenagers at the time of separation. He had been housing them and supporting them financially and non-financially. There was also a rental property which he was making additional payments on. Interestingly enough as well, he'd had a win at the casino 2 years prior to separation, 2 years before, 2.5 years after separation, which was of about $320,000. He used those funds to discharge a mortgage that the wife was living in. He'd also purchased her that house post-separation and discharged the mortgage for her. And he'd also had a significant increase to his superannuation accounts post-separation by salary sacrificing, and he also had a pretty good defined benefit account with the government as well. His post-separation contributions of the casino in the superannuation account represented about 25% of the pool in that case. It was a long marriage of 35 years, and in that case we ended up resolving the matter where my client, the wife received about 42% of the pool, which was the judge giving him obviously a benefit in the mediator, who was the formal judge, giving some kind of insight into he would be given some adjustment, but he definitely wasn't going to give a dollar-for-dollar adjustment in circumstances where my client had intermingled the casino win that he had, and also where the superannuation pool, the majority of that had been accumulated during the parties' very long relationship, and because he was getting close to his retirement age, the defined benefit was starting to balloon. This is, I guess, a really good case to kind of look at in circumstances where if the husband had been in a position to resolve matters closer to the time they separated, the things that he had accumulated post-separation wouldn't be included in the property pool, and certainly he had never received a dollar-for-dollar adjustment for the post-separation contributions that he had made. So really, I guess, honing in with clients coming to see you, depending on, I guess, the circumstance, but the majority of cases, the benefit particularly of resolving property settlement matters sooner rather than later, as post-separation contributions, as I said, are not going to equate to that dollar-for-dollar type of value. The last thing I wanted to have a bit of a talk to you about is special contributions. We'll talk about a case that is the leading authority in regards to this at the moment. So in this case, we had a long marriage of 29 years. In this case, the husband was considered to be the driving force behind the family business, and the wife took the more traditional role of being the homemaker and primary carer to the party's 3 children. There was a significant pool of millions and millions of dollars in this case, and so the husband was arguing that the reason that their they had the property pool that they had was because of his entrepreneurial skills of being able to work hard, and in fact he had the special contribution. Without those skills they wouldn't have what they had. At trial, despite the judge rejecting the words of a special contribution of the husband, he awarded the wife only 40% of the party's property pool. Both of the parties appealed in that case. The wife argued that the trial judge devalued her contributions in the long-term role as the homemaker and parent. As I said, the husband also appealed, and he argued that the trial judge had placed greater weight on his business skills, and therefore he sought more than 60% that he'd already been awarded. The full court rejected the husband's argument that he had made a special contribution, and the court found that he was only part of the reason he was able to exercise his skills in the business because he was freed from making the obligations of other family responsibilities that the wife was making at home whilst he was exercising his business skills. So in that case, the full court was satisfied there was equal contributions whilst different of the financial and non-financial relationship, didn't consider that one should be treated less important than the other, and the property pool in that case was divided equally between the parties. So this case is quite well known to family lawyers in the sense of the argument that special skills is dead as such, but that's really in regards to long relationships where no particular form of contribution is going to be weighed more heavily. In circumstances of a shorter relationship, again, where there's no children or a mid-length relationship as well, the court may be more minded to give weight to some exceptional contributions in those circumstances. So that's where we're just going to finish up for today. with our new webinar technology, we're not taking questions at the moment. In the next coming ones, we may bring that feature up. But at the moment, if there's anything further that you want to know, or you have any further topics in regards to family law that you need some answers to, please feel free to give me an email just at the law@mlynch.com.au, or give me a telephone call. I'm happy to have a chat on the phone, and since there hasn't been any interaction between us this afternoon, it'd be great to hear some voices back. I'd also just like to let you know, if you've got any clients that you think may need some family law advice, we do offer a fixed fee consultation of $330 including GST, which may be a good thing for clients to come and get that advice, to particularly if they're looking at separating, getting advice as soon as possible. I can't emphasise enough how important that would be. Also, I should let you know, I've flicked the slide already, but if you'd like Michael or myself or another solicitor from our firm to come out and have a chat to you further, please get in contact with us. Otherwise, thank you for your attention today.